pon kang tung galang no 125th Constitution Amendment Bill pula bangsa jai mek dam dia prang khala panel discussion long appoint pipi pondo autonomous state pen 6 schedule ko puthat se ele tum discuss pon po mate chingwai pon po la pen la bangsa discussion long gelake debate takali sita what is black and what is white aki kupima akelo kupima la pen constitution long kupima kedo la sote pensi sithan bonji lasik chuning rilo kibang ladak kibang aporte la pen injil ke thegiding dum han tame nale dum discipline pen maintenance ante message ku ladak ilitum jasemet he putak sithan bonji apot longri long pat aparman situm ka japon apot ladak kumane tapuson thurham pen lamgang tang pen tapuson langnodak pen tapuson behavior mang ilitum Lempon Federation tem senji pusi nilihin presiden pentamin ale tomban tuning wipon. Lahano la first session tampon pitpo karjupon kang tulo bang kalahano 6 schedule puli tom chethan piglo ong do atoma mangke 6 schedule ke chodor de potaning jelo 6 schedule B on opposite autonomous state in Anjibu. Some sections of the people says that 6 schedule is too small. So implementation of Article 244 is must for Karbi Anglong and Dimahasao. Lasila bangso alam he nelia prangsi pini kacopa pondo elitum Penelist law, become the resource person, Akea Isar, Elvin Teron, chief advisor to the CM Caribbean Long Autonomous Council, Alangli Pansinili, Aprangsi, Aporpi Pompo, Atima Alangli, Halloween, Kitam Puji Pusi, Ketana Palasi, Alangli Pansi, Aport Palam on the Kimpen, Nelly Aprangsi, Alangli Pansi, Aporpi Pompo.
So, good morning to everybody. My honorable panelists and friends who have gathered here. I'm glad to be able to begin the discussion today, set a tone perhaps of the discussion. And the question raised to me was, why is 6 schedule so inadequate that we have to resort to demanding for Article 244? That is the question presented to me. I normally don't refer to books as often as necessary, but today I have decided to use this book because this book is familiar to people of Karbiango. And most of what I speak, what I say, can be cross-checked from this book. Now, at the beginning there is a controversy about whether 6th schedule is separate from other parts of the Constitution. And the greatest proponent of that idea happened to be Justice Hidayatullah, who in his defense, in his dissenting note in the Barre case, Edmondson Barre case versus the government of Assam, very at length defended the right of the tribal people to self-determine themselves, and he called it a miniature constitution and sixth schedule need not be referred to other parts of the Constitution. That's the first thing. But when we go, which Justice B.L. Hansaria decided. He contested this contention, and eventually you can refer in this book, particularly in page 155 to 158, if you read. You can refer in this book, which says that my stand has been supported by the Constitution Bench of the Supreme Court. Now, what is a schedule? The Merriam-Webster online dictionary says, a schedule is a list or statement of supplementary details appended to another document. The legal definition of Merriam-Webster and Oxford Dictionary of Law do not differ too much. Oxford Dictionary of Law says, a schedule is an appendix to an act of parliament or other legislation that deals with points of detailed supplementary. And these points, why this is so, Justice Hansaria explained it in page number 156 of this book. And I read from him. The provision of the sixth schedule cannot be interpreted by forgetting the texture on which the Constitution has been woven. The sixth schedule cannot be completely insulated from the rest of the Constitution, and it is as much part of the Constitution as in any other schedule or provision. So he doesn't make any difference between schedules and other provisions. They are all the same in the Constitution. The sixth schedule has not provided by itself the complete constitutional arrangement for the governance of the territories in question. In so many matters, to wit, citizenship, fundamental rights, elections, union legislature, financial relationship, the tribal areas are interlocked with the rest of the country and the rest of the Constitution. So complete segregation of sixth schedule is not possible to visualize. This is a statement of the author of this book, B.L. Hansaria. So the truth is that some people may try to please us by saying that you are independent, sixth schedule is very powerful, and it is separate from the rest of the Constitution. It is a mini Constitution, and therefore we draw our strength from there. We draw our strength from there and try to find ways how to protect our people. That is the contention. Now, Justice Hansaria, in his so many interpretations of this, he also said that we have to look into the lacunae of the sixth schedule in order to interpret it properly. And that's why he went at length to go about explaining para by para in this book. And when you read this para by para, then you will find the lacunae and so on. And then he has referred to many cases, and if we read all the cases, we find the judicial review, and we know the contention and the conclusion made in the interpretation by the courts of the country. So this is one thing I want to say. Second thing what I want to speak is about the word autonomous. In point number 5 of the analysis, in page 155, if you see in this book. He referred to Hidayatullah, who said that the word autonomous signifying the possession of the right of self-government was regarded as the keynote of the sixth schedule provisions. So this is what Hidayatullah said. And in this, we understand that sixth schedule is a constitutional instrument of autonomy. It is constitutional instrument of autonomy, which is self-government. That much we can agree on. But when we talk of autonomy, this is what I want to stress today. The attributes of autonomy. I also spoke this in the meetings of the sixth schedule councils which have taken place recently in New Delhi and then recently in Shillong also. And I have stressed that sixth schedule, with all its fallibility, with all its inadequacies, have protected us for the past more than 70 years. In tribal states, they have done it wonderfully well, but in the non-tribal states, we have had problem of infiltration, which eventually resulted in the demographic imbalance against the tribal people that we have faced across, not only here, but also in Borone area, but also in Tripura. So we have faced these problems together. And it is important for us to establish that the autonomy which gives us through the sixth schedule is strengthened further. And one of the way of doing is amendment. Another way of doing is upgradation of this status to autonomous state. That is where we can strengthen the autonomy that we have. The question that comes in mind as we go about understanding the attributes of autonomy is this. Number one attribute of an autonomy is expression of will within the subjects conferred without being undermined by other authority. This is the first attribute. If I am autonomous, I must be able to express my will effectively without being undermined by other authority. It is my right, and therefore I should be allowed to express my will freely. May not be all. From the sixth schedule, I may not like to start an army. That is the subject not given to me. But when allotment of land, determination of its use, setting apart of land, and other subjects are given to me, I must be allowed to express and realize my will effectively. So this is the first attribute. And it is for us to examine whether we are able to express our will effectively. One of the areas that come to mind is, now we have a will to implement certain portion of the provisions of the sixth schedule, and we create a bill and then pass our bill here. Before passing a bill, we need to have an approval from the governor, and the governor is defined here in this book. When you see in the role of the governor, you will see it, that the governor acts on the aid and advice of the cabinet of the council of ministers, and therefore our bill gets stuck there for years together. In Kecheng Hills, even in Kecheng Hills, the Kecheng Hills district council CMs, they told me that even their bills are stuck for more than 10 years. Here, our bills are stuck for years together. It took just one amendment, one small amendment in the town committee rules to amend the government of Assam kept it, and they kept it for 11 years. Now, Karbiano Autonomous Council has about 8 bills pending in the state government for the last 3-4 years. They're getting stuck here. And therefore, that's why I say that this 6 schedule will give us autonomy. We are unable to express our autonomy effectively. We should have been able to express our will, the will of the people, without the interference of other forces who do not have anything to do with our thing. That is why we say that even the provision of paragraph 20BA is not sufficient until unless the word Council of Ministers is deleted from the paragraph 20BA of the schedule. Secondly, there are many things we think I will continue in my next point because of the time.
Yes, sir. We will allow 20 minutes time for one panelist.
Yeah.
After that, we will come back to you again.
Now, the second attribute of autonomy is that without depending on others. If I have expressed my will that I want to do this, I must have sufficient resources to do it. Unless I have the resources to do it, I have no other way of expressing my will. Even if I want to do something, if I do not have the money and the resources, I will not be able to do anything. And that's why the resources of the council is so important, which is being discussed across the Northeast. How to improve the finances of the 6th schedule. Now presently, what is the resources of the 6th schedule? If we go to examine, there is Article 275, which is the original link of the 6th schedule. Article 275.
So you come this point after.
No, because it comes in my point.
Okay. But your allotted time is up, sir. We will come back to this point regarding 75.
But if I don't speak about it, it will not. My argument will not be
okay. With 2 minutes time.
Yes. So the resources that we have is from paragraph 8, whatever taxation we can do. From paragraph 9, whatever share we get from the mineral resources. From the administrative charges that we deduct from the government department. All these things go into the deposit, or go into the district fund. I am not talking about the deposit fund. I am talking about the only the district fund. Then the granting aid coming from the government. Then the award of the finance commission, if it comes at all. If we have no actually right to get that one until unless we are linked to it, Article 280. So all those are, and the new source of taxes that have been given to us by 101st Constitutional Amendment in 2016 is taxes on amusement and entertainment. That is the new tax that is given to us. And all the resources put together, Karbianglong Autonomous Council used to collect about 40 to 50 crores in a year. The revenue expenditure of Karbianglong Autonomous Council at present is 300 crores. So we are far below our requirement. And therefore we have to look into that. The third point, that is the third attribute of an autonomy, is that you must have the executive wherewithal with which you can execute whatever will you have decided. And that is the magisterial power and the police force. Without that, it becomes very difficult to express your will. If you cannot express your will freely without undermining by some force, if you cannot if you do not have the resources to carry out your will because of the shortage of revenue, and if you cannot carry out your will by the process of by having the wherewithal, executive wherewithal of a police force and a ministerial power, then our autonomy becomes limited. This is what I want to say. And we should all work together. And that's why we say that we have, until and unless more legislation is made to remove all those inadequacies, sixth schedule will not be able to serve our purpose. And therefore, that is the reason why we have to migrate to Article 244A in order to remove those difficulties. The second National Commission for the working of the Constitution under Venkatachalaya in 2002, in 2000, which was appointed in 2000. In that report, a lot of discussions have taken place. I'm not going to the details, but if you look into all those things, we'll come to know that there is a national consensus in trying to improve the finances of the schedule, of granting of more autonomy. They have, because P.A. Sharma himself was the panelist chairman at that time, under Venkatachalaya. I will not be able to that detail, but my submission is this: the sixth schedule has powers that serve us. Sixth schedule does not have the power to raise our standard of living. At present, I'm talking about the original sixth schedule, and therefore we need something more to improve our finances, to improve our constitutional position in connection with the relation with the governor, and that can happen only through further amendment or through our upgradation into Article 244. Thank you.